Hello, everyone. I'm Kevin Gosztola, managing editor for shadowproof.com, back from London after covering the Julian Assange extradition proceedings. On today's show, we're going to be running down some stories from the last week and talking about whistleblower stories. We have an important development here because Senator Ron Wyden and Representative Ro Khanna have introduced something called the Espionage Act Reform Act. But for right now, I just want to remind you that if you hit the red subscribe button below the video, you'll be able to follow our show. And remember that Shadowproof is 100% reader funded and a supported website. Our ability to do this show depends on your financial support. So if you're able to help us keep this show going and grow our organization, if you appreciate some of the reporting you've been seeing over the past weeks, please check out our donation and membership options over at shadowproof.com/donate. So now I'd like to get to this Espionage Act Reform Act that was introduced, and particularly it was introduced in order to protect journalists. This is quite a development. It's really important. I'd also like to read a statement that I got from an aide to Ron Wyden, and it basically says that under the bill, the government could still prosecute Assange for the role he allegedly played in helping Chelsea Manning to hack passwords, but, and this is the crucial but, the government couldn't prosecute him for publishing classified information. So Ron Wyden was one of the few senators who spoke out against the indictment when there were 17 counts issued in April that went after Julian Assange for the publication of information, of classified information around the disclosures and leaks that Chelsea Manning was responsible for. Again, we're talking about the Iraq and Afghanistan war logs, the U.S. diplomatic cables, the collateral murder video, as WikiLeaks called it, and the Guantanamo detainee files. And he was someone who recognized, in fact, I have a statement right before me. He said, "This is about the use of the Espionage Act to charge a recipient and publisher of classified information. I'm extremely concerned about the precedent this may set and potential dangers to the work of journalists and the First Amendment." So he's somebody who recognized very early on that this was a key issue that needed to be challenged, this fact that the prosecution was being brought forward. But to dig into some of this Espionage Act Reform Act, it looks at the well-known area of this Espionage Act, which has been used to criminalize people like Chelsea Manning. It particularly aims to remove some of the vagueness and the interpretation that's been left up to prosecutors, which has given them the kind of wiggle room where we now see Julian Assange being prosecuted. So this is this is definitely intended to protect. It even says outright that the law is being proposed to protect journalists who solicit, obtain, or publish government secrets. And so this is an important step forward in trying to keep this from metastasizing further, because a lot of us have always said that the war on whistleblowers is truly a war on journalism as well. It aims to end the criminalization of disclosures of classified information related to signals intelligence to any member of Congress. So one of the things that Wyden and Ro Khanna want to do is expand the number of people in Congress who could receive information that is classified. It wants to cover the Federal Communications Commission, the Federal Trade Commission, the Privacy and Civil Liberties Oversight Board, and inspector generals as well when it comes to expanding the people who could receive disclosures that involve privacy abuses. So you might remember what happened around NSA whistleblower Edward Snowden and how when he made disclosures, there was attention to this Privacy and Civil Liberties Oversight Board. And I think there were questions about whether these people could receive the kind of information that he wanted to disclose that was highly classified, top secret material. And they're saying we should expand the number of people who could receive these disclosures so that they wouldn't be punished for having them, also that they could do work to respond to concerns from employees. And so part of this act too is expanding the people who whistleblowers could give information to. So there's less likelihood that they would be punished for making these disclosures. They also want to and widen somebody who's been known to stand up for people when it comes to protecting encryption, when it comes to standing up for technologists and people who are involved in cybersecurity who have complaints about the way government is undermining our security and our safety on the internet. And he says he wants to be able to protect cybersecurity experts from prosecution when they publish research showing discoveries of government backdoors in encryption algorithms. And that's something where when people who are researchers have shown that they have uncovered something, they face threats of prosecution because it's said that they're publishing vulnerabilities to systems that will make it easier for the government to hack them. So rather than rewarding them for showing that there are security vulnerabilities, the government is embarrassed and has tried to silence them from sharing this information. The intent is very clearly to make it so that this Espionage Act could only be used against people who have access to classified information. And that might be something that's worth discussing further as to whether that would be okay. One thing that caught my attention that raises some concern in my mind, but doesn't mean that this isn't valuable, what Wyden and Rokana are doing is that they have a statement in their summary where it says, every single person convicted to date under the Espionage Act could still have been convicted had this bill been law at the time they were presented. So what it means is these defects that we've raised attention to, we've brought attention to, we've talked about the manner in which the prosecutions of these people like Chelsea Manning, John Kiriakou, and Reality Winner, all these people that we've had concerns about how they were prosecuted because they couldn't raise a public interest defense. This doesn't really do much for them. It's not very clear what this does for individuals who want to be able to say in a court of law why they did what they did. It still seems to retain some of the problems related to strict liability, but what they are doing that's very good, and I say this without any reservation, is they want to go through the law and remove this vagueness about, okay, so it applies to whoever, it applies to he or she. They want to make it clear that it only applies to foreign agents, people who were clearly selling information or trying to procure information for some material benefit. And that, again, would also take away a lot of the room that prosecutors have to interpret the Espionage Act and abuse it in the ways that we've seen over the last 10 years. So I think this is a crucial step forward, what we're seeing Ron Wyden and Rokana propose. And then now we'll get to see what kinds of people in Congress, if anyone, will step up and see that is important, that it's very important to do something about the abuses of the Espionage Act. So let's move on to our next story, which I wanted to dig into what's going on here with this group that we've highlighted before. They're called the Public Employees for Environmental Responsibility, and they've highlighted the fact that Donald Trump went on television for a Fox News interview on February 24th, 2020. And he said, quote, "It's not a secret that we want people in positions that work with this president, not against him. And too often we have people in this government. I mean, the federal government is massive with millions of people, and there are a lot of people out there taking action against this president. When we find them, we will take appropriate action." And so they filed this complaint and submitted it to the Office of Special Counsel because they're concerned that he's talking about purging federal government employees who are disloyal. And they're bringing attention to this because it's going to undermine the core protections for workers. Specifically, they're concerned that it would allow for employment discrimination based on political preferences rather than an employee's performance. They're concerned about favoritism, or the fact that people might be coerced because of their partisan politics. They're concerned about reprisals or retaliations that may happen because someone engages in certain political activities. And this is really crucial for them to speak up. PEER is known for representing people who are involved in environmental protection agencies, environmental health agencies, or public health agencies in the government. And we're seeing that right now. There's a story that we're not spending time on this week. It's received a lot of attention, but we've heard about a coronavirus whistleblower within the federal government. I believe these are people in the Health and Human Services Department, and how they raised concerns about workers who weren't protected when they went to deal with evacuees from China. And so this is something that is important because to the extent that people are viewed as disloyal because they raise concerns about the Trump administration, to the extent that they object to the way public policies are being carried out, then those people deserve to be stood up for as Donald Trump tries to purge them from the United States government. So let's go on to another story that we have here. There's a update from the gray zone. We've talked about this. We've talked about the OPCW and how there are whistleblowers there who challenge the organization's efforts to basically suppress this investigation into an alleged chemical attack in 2018, back in April 2018. This was said to have happened. It was believed that Syrian President Bashar al-Assad was behind this attack. And so they sent in this group of people on a fact-finding mission to try to uncover what happened. But as the details were coming in and as they were analyzing what they had available, these inspectors, these people who are chemical weapons experts, those who are scientifically, they're able to make conclusions about what they were finding, they were suppressed. They were pushed aside as they followed their findings, and they did not lead to the answer that the mission wanted, which was to say clearly that this was Assad and that there was a chlorine attack that happened. So as what they were finding raised some doubts, we've seen that there was a suppression of them. And in the recent weeks, these people, there's two particular whistleblowers. There's Ian Henderson, a South African engineer and veteran OPCW official who's been out very prominently on this. And there's an anonymous OPCW official who passed on some letters to Aaron Mate over at the Gray Zone. And so I've got this in front of me. This is what Henderson wrote, which was, "We're long-serving and dedicated OPCW supporters. We both have reams of documents such as performance appraisals, emails, letters of commendation, and others that reflect a history of service at the highest level in terms of qualification, skills, expertise, leadership, integrity, and professionalism throughout our time at the OPCW. Does this not place the efforts by some to smear our reputations on questionable ground?" So what they're responding to is that OPCW itself has been going after these people and trying to smear their reputations and credibility because of the fact that they were willing to challenge them over their handling of this fact-finding mission. And so Henderson goes on, "As a manager, as the highest official in the organization, does this not lead to the question, why would a pair of the top inspection team leaders, both with impeccable records, suddenly go quote-unquote rogue? Our sole duty is to be true to the facts and the science, and once that has been achieved, we will gladly accept the proven and agreed scientific outcomes." So these are letters that, again, pressure the OPCW to be transparent, to be forthright and honest, and to reveal to the public what they see as being suppressed and hidden from everyone. And again, there's the anonymous official that says they're in the autumn of their careers with nothing to gain and everything to lose. This defies all logic that we would be going rogue. Why would we risk so much to push a personal view? Hardly. Something had gone wrong inside the OPCW. We wanted you to know. It's that simple. So that's what the anonymous official said in their letter. And This is something that we're going to continue to follow. It's definitely not over. It continues to be a lingering issue as OPCW refuses to address these problems within their agency. It undermines their credibility, and when it comes to assessing sites of alleged chemical weapons attacks, because they are clearly biased and not able to just follow their findings, because if it doesn't fit in with certain powers' foreign policy, then they're discouraged from revealing those findings to the world. That undermines their credibility. So I think what these officials within OPCW are going after is trying to make sure they maintain neutrality so that they are seen as people who can be trusted when they put forward their reports. And before we conclude, let's go and talk about Julian Assange. I've got an update here for you on WikiLeaks founder Julian Assange. Of course, around a week ago, we wrapped up a first week of extradition proceedings. I wanted to read to you from a letter that was sent to United Kingdom authorities from the Council of Bars and Law Societies of Europe. I just wanted to point out some really important concerns that are being raised with the UK authorities, particularly on the issue of how Julian Assange's communications with his lawyers have been violated, that he's been unable to have confidential communications with his attorneys. They dig into the allegations and what has been confirmed about Undercover Global, this Spanish security company that targeted him while he was in the embassy with a spying operation. And as they point out in their letter, laying out their deep concern, they say that it's their position that the European Court of Human Rights protects professional secrecy, and that it enjoys the heightened protection of Article 8 of the European Convention on Human Rights. Lawyer-client communications in relation to contentious proceedings are protected. It's absolute in the sense that there are no limits that can be applied. In particular, though considerations of national security might fail to be balanced against the right to confidentiality under Article 8, the right to a fair trial is fairly absolute. It's an essential component. They say that any intercepted material obtained without judicial authorization and in violation of the principle of professional secrecy or legal professional privilege should be ruled inadmissible in a court of law and be required to be destroyed. So that's a little bit jargony, but what they're saying is any of this material that was intercepted should not be evidence that's introduced, allowed into extradition proceedings, if he's brought to the United States in a trial, that this is something that should not be allowed to be part of court proceedings. All government authorities which have been found to have been undertaking unlawful surveillance activities should be made liable to having sanctions imposed upon them. There's a case that's unfolding in Spanish courts right now against the role of this company, and it should go after the role of the Ecuadorian government in this operation as well. They go on in their letter. There is serious concern that the illegal recordings of communication between Mr. Assange and his lawyers, which were obtained in manner referred to above and which may be in the possession of the security services in the United States, may be openly or secretly used in the criminal proceedings against Mr. Assange in the event that he's extradited to the USA. In these circumstances, and in the consequent absence of any confidence that the information obtained by the unlawful surveillance of Mr. Assange's communications, and so they go on through their letter to make it very clear that this is something that the UK authorities should not be tolerating. They should take a stand against. Of course, it's been really hard to get any of these authorities to care about the rights of Julian Assange. They simply do not appear to care at all. The UN Special Rapporteur on Torture has raised his concerns. That's Niels Meltzer, pointing out psychological torture is something that he endured while he was in the embassy, and that the UK bears some responsibility and that they should do something to protect his rights. And yet they insist that the UK has no role, has no responsibility when it comes to the torture, the inhuman treatment that Assange experienced. So they basically feel that their hands are clean and that there's nothing they have to do to step up. We have a judge that refuses to make any calls to the prison to make sure that his rights are protected while he's in Her Majesty's Belmarsh prison in Woolwich, London. And so this is something that's hugely troubling because we have clear examples of rights violations, and they're not being remedied, and they're not something that any of these authorities really feel like they should do anything about. So that brings us close to the end of our show. I have to just cover some basic details that we usually run through at the end of every episode here. Chelsea Manning has been in jail for 358 days. That means that next week we'll mark we'll mark 1 year. It will be 1 year next week that Chelsea Manning has been in jail resisting this grand jury that was set up to destroy WikiLeaks. There's $249,000 in fines that she owes at this point. She's being fined $1,000 a day for resisting this grand jury. Julian Assange has been in jail for over 325 days since his expulsion from the Ecuadorian embassy. We've got Reality Winner in prison serving her federal sentence at FCI Carswell in Texas. Terry Albury is in a prison and coming up, believe so, in this month, although things might have changed. So I definitely think it's worth trying to find some kind of an update. But scheduled for this month, we have Daniel Hale, who's supposed to be going on trial as an alleged drone whistleblower who provided the documents on drone assassinations to The Intercept. And I mean, unless he takes a plea deal, I presume that this is going to be moving forward, or unless it's been postponed, it would be moving forward in Alexandria, Virginia, in the Eastern District. He's facing Espionage Act violations for releasing these documents allegedly to The Intercept. So these are all cases. These are all individuals we're following. They are people who are the victims of the war on whistleblowers that was continued by the Trump administration, and we'll keep tabs on these cases going forward. Every week we're following what's happening with them. So I want to thank you for watching this show. We skipped a couple weeks because I was in London doing coverage of Julian's extradition proceedings, and as that happens, we're going to have daily updates instead of having this regular show. But we do this show every Thursday about this time. It streams and then it archives, and then we post the show on our website and we share it. And it's our way to cover whistleblower stories that are flying under the radar. A lot of times the media talks about whistleblowers that they care for, especially they seem to really want to stand up for the ones that are opposing Donald Trump. And they are really inclined to support partisan whistleblowers, like we saw with the Ukraine call whistleblowers, but people who are challenging institutions and entrenched power, they don't always get the kind of support that they deserve. And so we want to do this show regularly to highlight these whistleblower stories that aren't getting attention, and to again remind you that these cases are unfolding and that they matter. So thank you for watching this week's episode, and we'll be back next week.